Hello everyone, welcome to Court with Krissy. Today's defendant drove recklessly, causing her passenger to be paralyzed and his dog to be killed. She's in major need of a reality check, and I think she gets it from the prosecutor. In addition, we get a new Debbie Davis eye roll. I hope you like it. Court with Krissy is now in session.
Just answer her.
Yeah. Right here.
Good morning. Ms. Claxton, are you with us?
I am. When I spoke with Ms. McLean, she indicated that she had hired counsel.
Ms. McLean, who is your attorney?
Sean, with the 360 law, I tried to call him this morning to remind him that I had arraignment and he didn't answer.
Okay, so it's Mr. Warden. Ms. McLean, are you still with us?
Yeah.
Okay, so that's Sean Warden, is that right?
Yes, sorry.
That's okay. So what I would suggest is maybe you can mute yourself, but to try to get a hold of Mr. Warden once again. If you have retained him, he needs to be here for your arraignment.
All right, let me try again.
Thank you.
He didn't pick up.
Okay, so it does not appear as though he has filed an appearance with the court. So for arraignment purposes, Ms. Claxton, are you willing to assist in the arraignment? Or I don't show an appearance from Mr. Warden?
I guess if we can just wait a few minutes to see if Mr. Warden does appear, certainly if she's hired counsel, then she has the right to have her hired counsel here with her, if that's okay.
Sure. So Ms. McLean, you're welcome to just mute yourself, and if we could wait for, I'll give Mr. Warden maybe about 10 more minutes.
Thank you so much.
You're welcome. Miss Henry.
Yes.
So again, we don't have an appearance from Mr. Warden, but I want the case to start moving as quickly as possible. Would the people have any issues rescheduling the arraignment, but as soon as possible?
I would.
Okay.
I wanted this to happen when she was picked up almost 2 weeks ago. The victim wants conditions put in place more than are already in place right now. I have serious concerns, and I would like it to happen as soon as possible. I did send a message to Mr. Warden. I guess the other thing too is do we know that she actually paid him or she just talked to him? And when did it happen? Because he's usually very prompt in getting things filed with the court.
Ms. McLean, have you, you're muted, but have you paid a retainer for Mr. Warden?
No, I had my first meeting with him and I emailed him my court hearing and I was waiting for him to get back to me. So I would preferably want to wait for him, as I want to hire him as my lawyer.
Well, I understand that, but you have not yet hired him and that you've not yet paid the retainer. So I understand that you've had your first meeting with him and that you will intend on hiring him. But I think that it's to everyone's benefit, including yours, that we proceed with the arraignment, and I'm going to ask Ms. Claxton to assist.
Okay. You're telling me to go pay for that.
I don't hear you. Stop.
Ms. Claxton?
Yeah, I'm available. I'll just need a breakout room, obviously.
Thank you. So Ms. McLean, I'm going to ask to place you and Ms. Claxton in a breakout room. It's a place where you and she can have a private conversation so that she can go over the issues regarding the arraignment before we begin, okay?
Thank you.
Yes. Your screen will ask you to join the breakout room, and when you're done, please return to this meeting. Thank you, and we are on the record in case number 24-1992FT. Ms. Claxton, did you have opportunity to review the allegations on the complaint, nature of the offense, and the possible maximum penalties with Ms. McLean?
I did, and will waive a formal reading as indicated to the hearing counsel.
Ms. McLean, I'm going to remind you that you have the right to remain silent. Anything that you say, orally or in writing, can be used against you. You have the right to have an attorney present during any questioning. If you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. You have the right to a preliminary examination. In this case, it would be scheduled for June 10th at 11 a.m. with Judge Cooney. Also, on June 3rd at 2 p.m., you would have a probable cause conference. Ms. Claxton, bond has been set in this case. Do you have questions or concerns regarding the bond?
No questions, thank you.
And Ms. Henry is here from the prosecutor's office. Ms. Henry, questions or concerns regarding the bond?
I do, Your Honor. So I have met with the victim. We're here. It's my understanding there's been comments made by the defendant to the victim and or his family. She doesn't understand the seriousness of what happened here. She thinks really this isn't that serious. She doesn't understand. She made a comment that it was just a crash. What's the big deal? Well, the big deal here is we have a 20-year-old who, as a result of her reckless behavior, is now paralyzed and will be in a wheelchair for the rest of his life. This was extremely close to an operating while intoxicated case. Had there been other circumstances, this would have been. So with that, I think with her reckless behavior in the driving, the alcohol consumption, we're asking for a few additions and changes to the bond that's currently set. So we would be asking for no driving. We would be asking for, in addition to no alcohol, there would be additional daily testing, not just discretionary. There's also been comments where she has a possible flight risk, making comments about how she has a passport and she'll just leave. I'd also ask, not only is there no contact with the victim, but there's no contact with his family, whether that be through third party, social media, any of that. She has contacted his family, no driving by his residence, any of that. I mean, she's making faces right now where she thinks that this isn't serious. And I guess that's part of it here.
Those aren't true. That's why.
Okay. Thank you, Ms. McLean.
I don't even
Again,
have a
the golden-
passport.
Hold on. A golden rule for you is to remain silent. If you'd like to be put back in a breakout room with Ms. Claxton to discuss some of these allegations or issues, I'm happy to do that so that Ms. Claxton might be able to speak on your behalf.
Yes, please.
Ms. Claxton?
Sounds good.
Once again, we're on the record in case number 24-1992FT. Ms. Claxton, you have information that you would like the court to know with regard to the additional requests for bond condition?
Yes, thank you. In speaking with Ms. McLean, it sounds like she, as she understands it, her license is restricted right now anyways. She is working, so we would, I guess, ask that she be able to drive for work, and certainly any medical appointments that she should need to go to. I think that's probably fair. She has no issue with the no contact. She explained to me that she has a friend who lives very close to the victim, and that's where she was going. And so she's not trying to make contact. She also wants the court to know that she has also received death threats as part of this. So we'd ask the court to take all of that into consideration in assessing the bond today.
Colleen, regarding the bond, I will continue the 50,000 personal recognizance piece. I'm going to add additional conditions. So the additional conditions are going to be that you will take and pass daily PBTs, proving that you're not drinking, that you would also submit to discretionary PBTs. You'll have, I think you did have a benchmark. You're going to have another immediate urine screen and 4 times per month urine screens hereafter. You'll have no contact in any manner whatsoever with Mr. Raycraft or any of his family members. The no contact means no phone calls, no messages through other people, no mail. You may not text message nor through any social network have any contact with him. And that's absolute. That goes into LEAN, the Law Enforcement Information Network, so that if you were in violation of any of the conditions, especially with regard to the testing and the no contact order, your bond would be revoked. There would be no bond, right? You would be arrested and there would be no bond. So please understand how important that is. You may not, you'll stay 500 yards or more away from Mr. Raycraft. So if the friend that you're visiting is closer than that, you can't visit that area, right? You'll not use or possess any weapons of any sort for any reason. You'll have no threatening, intimidating, harassing, or violent behavior towards any person. You'll be respectful of all court employees and care providers during the course of your case. Regarding the driving, I don't know what the restrictions are, and it would surprise me if there are restrictions, certainly not based on this event. Ms. Claxton, do you have any other information regarding the restrictions?
No, she just indicated that it was her understanding that it was restricted in the first place for work purposes and then medical emergencies. And I think that that's fair moving forward.
Well, so driving for purposes of work and not during the course of work. So work means to drive to your employment and then you will be able to ride with others from your work. Is that right?
No, I drive, I'm a cleaner. I own my own cleaning business, so I drive to clients' houses and leave their house and come back home.
Okay. Well, you'll need to provide a list of your clients and your schedule to Community Corrections Pretrial Services so that they are aware of where it is that you'll be driving and only will then be allowed to drive to and from work, and it has to be verified through Community Corrections.
That's a little hard because my clientele reaches out to me any days when they need cleaning, not a set schedule like a 9 to 5. So
so you know what, Community Corrections Pretrial Services has email. I'm pretty sure you could probably email that information if necessary. I am going to order that you'll not drive unless it is supervised by Community Corrections and authorized by them for work purposes only, for medical appointments, for court appearances, period.
And Magistrate, would that also include meeting with her attorney?
yeah,
Yes.
thank you.
And also for testing. So you'll need to begin the testing requirements, the additional testing requirements today. So that would also be for the additional testing. The 86th District Court will email you a copy of the referral form regarding the additional testing requirements. You will be, in addition to requiring that you're supervised as far as your work travels, you will be required to do a FACT app through Community Corrections, which is a check-in. So it's a daily check-in with Community Corrections. So you'll need to contact Community Corrections. It was a condition of your bond. If you have not already done that, please make sure that you call them immediately so that you can get information regarding the court FACT app, as well as provide them with information as far as your travels. The court will email you a copy of the referral form regarding the testing, increased testing requirements, daily PBTs, an immediate urine screen, and 4 times per month hereafter. Ms. Claxton, do you have any questions?
No questions, thank you.
Ms. Henry?
No, Your Honor. Thank you.
Thank you. So, Ms. McLean, you will need to contact Community Corrections immediately. Make sure that you get the email from the 86th District Court by 3 o'clock. If you don't, make sure that you call the court to verify your email address, which we have on file. Maybe I'll verify that with you. Is it? All right. So your preliminary examination, the next time that you'll appear in court, and that's going to be on June 10th, 11 o'clock with Judge Cooney. June 3rd, you're also scheduled for a probable cause conference, and with that, you are free to leave the meeting.
What time on June 3rd?
What time
On June 3rd.
Or what?
for June 3rd?
The probable cause conference is not a court appearance. It's via Zoom if necessary, and it's at 2 p.m.
2 p.m. Thank you.
You're welcome.